जाधव सर, करायचं का स्टार्ट सांगा. आतापर्यंतचं सगळं डिलीट करा त्याच्यावरलं. आता फ्रेश सांगा मला. So we are going to switch on a discussion on complaint to magistrate. Section 223 to 226. A criminal law generally come in a motion when the victim or relative of the victim or any person who has knowledge about the commission of crime, he informed the police station that the so-called cognizable or non-cognizable offense is committed by known and unknown person. If offense is serious in nature, under section 173 of the BNSS, offense is registered. And as soon as offense is registered, the investigation officer has to start the investigation. As a part of investigation, he has to proceed to search the places, collect the evidence, effect the arrest. Wherever required, the forensic department is to be deployed, medical department for conduct of the examination, medical examination, panchanamas, inquest reports. In accordance with the nature of the offense, the investigation officer has to take the necessary initiative. If arrest is effected within the stipulated time of 24 hours, the accused is supposed to be brought before the nearest magistrate to check the legality of the arrest. And magistrate think if police custody is required, then grant the police custody. Otherwise, he is sent to the magisterial custody. We use the term judicial, 60 days or 90 days, whatever it may be. So within the span of given timeline, the investigation officer has to conduct the investigation, collect the evidences, and make a compiled report. And such a report is to be submitted to the magistrate under section 193 of BNSS. Once a report is submitted by the police, accordingly, the magistrate take the cognizance of the offense. This is one of the mode to take the cognizance of the offense. This is called cognizance of offense magistrate has taken on the police report. There is one more mode through which magistrate is empowered to take the cognizance of the offense. That is complaint to magistrate, which is governed by section 223 to 226. This what we use the term, the magistrate take the cognizance of offense other than or otherwise than on the police report. What term is used? It means that when police refuses to entertain the informant at the police station, despite the offense, the nature of the offense is serious, so remedy is given. the victim, how he can bring the law in motion. So we are going to switch on a discussion on how a complaint is to be made to the magistrate. The chapter is 16th of the BNSS. The title is Complaints to Magistrates, section 223 to 226. These provisions cumulatively prescribe how magistrate may receive the complaint, and after receival of the complaint, how complaint is verified, how complaint is processed, and how complaint is decided. In old or earlier CRPC, wherein the provision was section 200 to 203. The very aim of section 223 to 226 of BNSS is to ensure authentic complaint move forward, while false, frivolous, bogus, incorrect, incompetent complaints should be filtered out, and those complaints which has credence, which needs to be entertained, are to be processed, are to be decided. For this purpose, section 223, 226 provide the mechanism, how complaint is received, how complaint is processed, how complaint is filtered, how complaint is decided. What is the nature and scope of the complaint under section 223 to 226? The nature of the complaint lies with a complaint regulate the initiation of private complaint before the magistrate. For your information, we may use the term whenever we are informing to the police station, police department or police officer, we use the term, I have made a complaint to police. Under BNSS, complaint made to magistrate has, by nature, it is formal, it is official then. So these complaints regulate the initiation of private complaints before the magistrate. Under certain circumstances, a complaint can be made to the magistrate, not each and every case. The very nature of private complaint is it ensure judicial verification before compelling a person to face criminal trial. It includes safeguard for accused person, procedural fairness, and even special protection for public servants. What is the scope? What is the domain of the complaint? It applies to all complaint based cognizance taken by the magistrate. A magistrate take the cognizance of offence by way of private complaint, and it covers some stages. This is the scope. First, a complainant who made a complaint is examined, first thing. After examination of complaint, if it appear to the magistrate that the so-called complainant who made complaint lacking the jurisdiction, the complaint needs to be filed at some other magisterial court, but mistakenly he filed at somewhere else. So as soon as the magistrate is realized complaint is to be transferred, then complaint is transferred. Third is postponement of process and ordering inquiry and investigation. Inquiry or investigation. As soon as complaint is read out by the magistrate, and when it appears that whatever contention made, whatever allegation made by the complainant against the so-called person, accordingly he is stating so and so person has committed so and so offense and cognizance is to be taken. So whatever story he is stating is whether made out a offense or not, the court has to look into. If it appear to the magistrate that whatever allegation made by the complainant, somewhere gap and lack is there, something needs to be searched and researched. Whatever stated is not a complete thing. Something remains to be searched. So magistrate is empowered to direct the police officer to investigate the things appropriately, to make a complete story. Then necessary things will be processed. So magisterial power to instruct, direct, to conduct the further investigation. And fourth stage, if it appear to the magistrate there is no credence in entertaining the complaint, because complaint is either frivolous or similar sorts of nature, sometimes it may be abuse of the process of law, the magistrate is empowered to dismiss it, reject it, because there is no sufficient ground to take the cognizance of the offense. If it appear to the magistrate, magistrate can dismiss the complaint. So these are the four areas through which the private complaint is entertained and processed and decided. What is the importance of the criminal complaint then? Already we have that much hierarchical police mechanism, machinery. Despite of it, why magistrate has to take the cognizance of the offense on the basis of the private complaint? The significance lies with to prevent misuse of criminal justice system. No one can take the law in hand, and no one can abuse the process, misuse the process of the law, even protect the public servant from harassment through false complaints, ensures only prima facie and legitimate cases should be proceeded for the trial. Each and every kind of information and complaint is to be processed and entertained and filtered, and then unnecessarily court shall not waste the time. Conducting trial is not a easy business. It requires much machinery is to be engaged. Time, money, judicial system. So there shall be a scrutiny before sending a matter to the trial. Equally, the significance lies with it enhances judicial efficiency by assessing cases to proper jurisdiction and enabling a preliminary scrutiny. Now we are taking provision section to section for the discussion. Section 223 provides examination of the complainant. It means that when a private complaint is made to the magistrate, the core provision is 223, which regulate how complaints are first entertained. The magistrate taking cognizance of the offence must examine the complainant on the oath. This is the first phase. The complainant is to be examined on oath. Whosoever witnesses shown in the private complaint are to be examined. Their statement, whatever they are deposing before the magistrate, is to be recorded. Their signature is taken, and thereafter magistrate has to sign. A question may put forth sometime, why magistrate has to examine the complainant? The purpose is to ensure that whatever he has stated, is there any credibility? If he states something fabricated, he will be punished. So the consequence one should know, so that unnecessary cases shall not be brought before the court. Unnecessary complaint shall not be filed anyone. And therefore, first to ensure that whatever he stated in the complaint, whether he has made it or someone has, so to ensure the trustworthiness of the whatever fact stated concern, the examination is conducted, and even witnesses are also examined, and their signatures are obtained, even magistrate to sign it. Proviso. When complainant is examined and whatever facts stated by the complainant, if it appear prima facie, the offence is committed. So statement made out the case, then accused must be given an opportunity of being heard before the magistrate, before magistrate take the cognizance. If magistrate is realized the allegation made by the complainant is made out a offence, before issuing the process, the other side is to be heard. The examination is not required under certain circumstances, when if the complaint is filed by the public servant acting in his official capacity, or even if complaint is filed by a court, or a case is made over to another magistrate under section 212. Except under these three circumstances, the court has to give the opportunity to other side, and thereafter the necessary process are processed. If after examination, if matter is transferred, the new magistrate or successor magistrate shall not re-examine the same complainant again and again. Once examined, the magistrate realized that matter is to be handled by someone else magistrate. The matter the magistrate has to examine and transfer the matter. Wherever the matter is transferred, the so-called magistrate shall not again examine the complainant. Under this provision, a special protection is given to the public servant. Magistrate cannot take cognizance of offence against a public servant unless the public servant is given an opportunity to make assertions and a report from a superior officer explaining the incident is furnished. So whenever the private complaint wherein the respondent is the public servant, means complaint is against public servant. Under these circumstances, the magistrate never take any cognizance unless and until the other side is heard, unless and until the superior officer has explaining the incident is furnishing. Then if magistrate realize that there is need to take cognizance, then court will take cognizance. The purpose is just to prevent harassment of officials from performing their official duties. Otherwise, against public servant there may be numerous complaint a general public may file. So there may be hindrance of the public work then, and therefore each and every complaint at all not entertained, at all not admitted, at all not processed unless and until the public servant is heard or his superior officer has given any assertion. Then and then only matter will be proceeded, otherwise no. The purpose is the public official shall not be harassed unnecessarily. That much is the reason. That is the reason. Section 224 of BNSS provide procedure when the magistrate is not competent. A complaint is filed, private complaint is filed, but magistrate is not competent. If a complaint is filed before a magistrate lacking territorial or a legal jurisdiction, it means that the private complaint is filed at a wrong court, before the wrong magisterial court. If a complaint is filed before a magistrate who lacking either territorial or a legal jurisdiction, written complaint, written for presentation to proper court with appropriate endorsement. In a civil litigation, what we have observed, when plaint is presented at a wrong court, unknowingly, plaint is to be presented to the junior division, but it is presented to the senior division. What senior division has to do? Senior division has to write a direction. The plaint is to be presented before the appropriate court. So similarly, wrongly, if private complaint is filed at the wrong magistrate court and the magisterial court is realized that this court has no jurisdiction, then the magistrate has to endorse and direct where the complaint is to be filed after due endorsement. And even if there is an oral complaint, the complainant is directed to the proper court. So private complaint can be filed either in a written form or in oral form. If it is in a written form and if it appears to the magistrate this magisterial court has no jurisdiction, necessary endorsement is met and directed where the complaint is to be filed. If it is oral, then orally it is directed where complaint is to be filed. The importance of this phase lies with to ensure cases are filed before the correct forum, so that there shall not be any jurisdictional error may cause. And to avoid the jurisdictional error, to avoid the invalidating the proceedings in upcoming days, better the matter should be processed by a appropriate court who has complete jurisdiction. Now, section 225 deals with postponement of issues. Postponement of issues mean what? Issues mean when a complaint is filed, complainant is examined, whatever stated in the complaint and whatever things accompanied with the complaint, if it made out the offense and magistrate is realized that the cognizance needs to be taken. Once a magistrate arrived to the conclusion, cognizance of offense needs to be taken. The magistrate issue the process. Issue the process means in accordance with the nature of the offense, issue the summon to the other side to appear and to answer the complaint. So under what circumstances processing of issues can be postponed? This section empowers the magistrate to delay issuing process if the offense in accordance with the nature of offense, the magistrate may issue summon sometime, even can issue the warrant to effect the arrest. Whatever may be the nature of the offense, whosoever may be the accused, issuance of the summon or of warrant can be postponed if certain circumstances exist. And in this regard, the power of magistrate, the magistrate may, keeping in mind the prevailed circumstance, postpone the issuing process and either conduct an inquiry himself or direct the police or the so-called authorities to conduct the investigation, limited investigation, to determine whether there is sufficient ground to proceed to take the cognizance of the offense. Conducting inquiry mean what? Conducting inquiry mean magistrate read out the complaint, whatever enclosure with the complaint, whatever things required further, or to ascertain whatever stated, if there is a lapse and gap or something can be inferred. If the statement stated is puzzling or leaving a scope to infer something, so magistrate can ask the complainant, Mr. Paragraph number 7, once you read, what do you exactly want to say? It conveys double meaning. If you are saying yes or no, so court can conduct an inquiry. And even sometime the complaint is of such a character, the complaint cannot state the things complete, because stating the things is not in his hand. It required a police machinery to be engaged and to search the things and bring the truth before the court. So police are the best mechanism. So magistrate is empowered to direct the police authorities to conduct the limited investigation to know the real truth, and then the court magistrate can take the cognizance of the offense. Even postponing issuing process, either to conduct the inquiry or to conduct the investigation. What is the nature of investigation? It is also called post cognizance investigation. This is called post cognizance investigation. Court has decided cognizance is required. The court has taken cognizance, but court want to know the story complete, which is not stated. Then, therefore, therefore the word is used, post cognizance investigation. So it is limited and focused, not a full-fledged police investigation. It is just to know whether offense is made out or not. During conduct of the trial, everything will be come in play. This is mere inquiry, whether matter is triable or not. For the conduct of the trial, whatever material required, whether it is exist or not. If it is exist, then court will proceed, otherwise no. And therefore, the investigation or inquiry is to be conducted, and till the inquiry and investigation is conducted, the magistrate is empowered to postpone the issue process, issuing of the summon or issuing of the warrant to the so-called respondent. And the purpose is to avoid the summoning or warranting an accused without preliminary satisfaction of genuine case, whether the private complaint filed, is there any credibility? Is there really offense is committed or not? Unless and until it is ascertained, how court can proceed, how magistrate can proceed? For taking the cognizance of offense, court magistrate may postpone the issue process and direct the investigation or conduct the inquiry. Otherwise, what would happen if magistrate issue warrant? The respondent will come, the police effect the arrest, and he is brought, he is accused then, and thereafter court realize there is no evidence. What is meaning in effecting the arrest? Then what is the use of Article 21? Life and liberty. Where is life and where is liberty then? Any can frivolously file a complaint, convey to the court, magistrate, unless and until full inquiry, full investigation, unless and until the court magistrate realize the matter is triable, court shall not proceed to issue the process. And unless and until the magistrate is satisfied, magistrate shall not issue the process. And therefore, this power is with magistrate to postpone the issue process. Now, we are proceeding towards section 226, dismissal of complaint. If after inquiry under section 226 or limited investigation under section 225, no sufficient ground exists or no credence exists in the complaint, whatever stated after due conduct of inquiry or investigation, if it appear to the magistrate, there is no substance, the case cannot be made out, story stated cannot made out the offense, matter has no credence to conduct the trial, matter cannot be sent to the trial court to conduct the trial. The magistrate before whom the private complaint is made, the magistrate can dismiss the complaint and record the reasons why private complaint is dismissed. So, dismissal of complaint accompanied with reasons for its dismissal is required. The purpose behind showing of reason for dismissal of the private complaint, the reasons are, it become a safeguard the accused from baseless or vindicative complaints. No one can abuse the process of law. The frivolous litigation cannot be initiated, and it create a recorded basis for judicial review. If suppose a revision is filed before the superior court, let the superior court realize on what ground the private complaint is dismissed. The power to dismiss the complaint, the importance lies with to prevent the unnecessary criminal process and protect the individual liberty. Merely if someone is served by the magisterial court, a person and his family will be in trouble. No one knows how long process may go. And if there is a warrant, the police will come and effect the arrest. My life and liberty will go. Where is the constitutional guarantee? My life becomes stigmatized. Keeping in mind the prevailed seriousness, the magistrate is empowered under this provision to have scrutiny and empowered to dismiss the case if there is no substance in the litigation or in the private complaint, to prevent the unnecessary criminal process against an innocent guy. Overall, the criminal complaint establishes a structured complaint handling mechanism ensuring procedural fairness, provides safeguards for accused, especially public servant, allow magistrate to screen out frivolous litigations, complaints through inquiry, through limited investigation, maintain judicial efficiency by ensuring proper jurisdiction, prevent harassment of citizens by restraining unwarranted criminal process, and strengthen transparency via recorded reasons for dismissal. So in this way, the private complaints are entertained, processed, and decided. These are the section 223 to 226 of the BNSS. If anything else, it may be asked. ओव्हर. काय विचारायचं असेल तर विचारा. सर 223, 224, 225, 226. पुढचं घेऊ. Now we are proceeding towards one of the important chapter of the BNSS, that is order for maintenance, from section 144 to 147. 144 ते 147. Order for maintenance. You know, being student of jurisprudence, there is one chapter, that is obligation. Jurisprudence says, once you become husband, once you become father, you owed a responsibility towards the dependent, and you cannot refuse. Otherwise, you shall not marry if you are not capable. If you marry with someone, then you are obliged. You remain a gentleman. Why you become Mr.? Yes. If you are marrying, you are inviting obligations. So, the chapter on maintenance under BNSS is the replica of the chapter under jurisprudence titled as obligation. So under Bharatiya Nagrik Suraksha Sanhita is the secular law, basically. 2023 provides a chapter, maintenance. It refers to the legal obligation, provide financial supports to dependents who lack means to sustain themselves. This concept is carried forward from Criminal Procedure Code under section 125 to 128. The old law, the CRPC. Now, the BNSS under section 144 to 147. This is reenacted. Again, the law is secular. Now, what is the meaning of maintenance under BNSS? Podgi, what it is? Financial support obligation. Maintenance in the sense, you have to maintain means under BNSS, you have to give financial support. You cannot give food. You cannot give clothing. You have to give money. Other than money, no. Only money. What expect the BNSS? Financial support obligation. It means the term refers to the monetary aid necessary for food, clothing, shelter, education, medicinal care of such a spouse, of such a children, of such parents. The chapter maintenance under BNSS has social justice imperatives. It is viewed as a right of vulnerable groups, individuals, ensuring no one become destitute due to familial neglect. In earlier days, it was a pious obligation of son to maintain their parents, maintain the mother, maintain the father. But now the obligation is legal. The son is bound to maintain his old mother and father, to his kid, to his wife. If he is neglecting and refusing to maintain, the BNSS come in motion through section 144 to 147 and compel a person to pay for your negligence because they are in destitute situation. This is your familial neglect. You are bound being husband, you are bound being father, you are bound being child, son. What is the nature of the obligation under chapter maintenance? It is a statutory duty and enforced by court. It is not mere moral obligation. It is legal obligation. It is statutory duty of each person, disregard of which belong to which religion. No. A person being a citizen of this country, he is in accordance with the statute, accordance with the law, he is bound to maintain. And therefore, a external agency is prescribed to compel him to maintain. And therefore, under BNSS, a judicial magistrate first class has authority to issue orders of maintenance under section 144. And this provision is a secular, inclusive and it covers individuals regardless of religion or personal law. Any Hindu, Muslim, Christian, Parsi, Jews, whosoever being citizen of this country is bound under section 144 to maintain his wife, maintain his parents, maintain his kids. If he is neglecting to maintain them, the judicial magistrate first class is the authority, is empowered to enforce the right of the wives, children and old age parents to be maintained out of the fund which magistrate compel them to pay. So it covers the wife, including divorced, separated, but she should not be remarried. If she is remarried, then obligation is ceased. Wife of which kind? Though it is divorced, though it is separated, though it is yet not married. Children, legitimate, illegitimate, minor, incapacitated, minor child. Now question may come, legitimate, illegitimate, what does it mean legitimate and what does it mean illegitimate? If he has begotten and born, though in the eyes of the world the child is illegitimate, but for him remains legitimate. For other relations it may be illegitimate, for him it become legitimate. If it is incapacitated, whatever handicapness, though it is minor, incapacitated major child, minor, major birth, but incapacitated, illegitimate, legitimate. Parents who unable to maintain themselves. If parents able to maintain themselves, then they cannot. If they are unable to maintain themselves, then a person is liable to maintain his parents. Dynamic relief mechanism is prescribed under the BNSS, under section 145. Provision for interim maintenance during the litigation. It means that a wife, a child, or a parent, a mother or father, whosoever may be, when they initiated a matter in a magisterial court for maintenance, no one knows how long this application may entertain and court reach to the conclusion, how much maintenance court may calculate. It will take time. So till the final decision appear in the matter, section 145 says, time being, the court pass some interim relief, some amount during the course of pendency of the matter is to be paid by the respondent to the applicant. So maintenance order can be altered, can be increased, can be decreased, or can be cancelled due to changed circumstances under section 146. Now enforcement with penalties. This is the nicety of the BNSS. If there is no compliance of the order of the judicial magistrate first class, it attracts the penalties. Warrant will be issued, fine will be imposed, imprisonment even up to 1 month can be for each kind of default. It's prescribed under section 147. However, the debt remain even then imprisoned. What is the scope of maintenance under BNSS? Beneficiaries who are 1. Wife, 2. Children, 3. Parent. Who are the beneficiaries under the chapter maintenance? Number 1, wife, 2, children, 3, parent. Means there are 3 beneficiaries under the chapter maintenance. Wife, what kind of wife? Wife divorced, wife judicially separated, but she should not be remarried. If she is remarried, there is no question, the matrimonial tie is ceased, and therefore there is no question. Whosoever new husband, he has to take care of her. Children, minor, not major. Even major, but if they are mentally or physically disabled, challenged, and they are in need to be maintained, they are not capable to maintain themselves because of the mental or physical hindrance. Parents, which parent? Biological. Parent, even adoptive. Section 11 of the Hindu Adoption and Maintenance Act is very important. This provision says that the adopted son has equal right with the natural born son for all purposes. So similarly, if there he is benefited, here he is obliged under BNSS. So a father who has adopted you and you became the son of him, then you are owing the obligation towards the so-called father and mother who adopted you. So what kind of relief under this provision the magistrate may grant? One kind of relief, first is interim maintenance. Interim maintenance can be given and the relief is extended up to the final decision appear in the matter, mean till during pendency of the application. If it is disposed, the interim relief granted is abated automatically. And second one is final maintenance, that is decree under section 144 of the BNSS. This is final maintenance. First one is interim maintenance and second one is final maintenance. Section 144 of the BNSS provides that court with the authority to order monthly maintenance for dependents if a person with a sufficient means neglect or refuses to support them. Now, here is the very important crux, is that who can claim maintenance? Two things we find here. One, who is claiming maintenance, he should be incapable to maintain himself. And other thing, a person who is capable to maintain but he is refusing to maintain. Who can claim maintenance? Wife, including a legally divorced woman who has not remarried and she is unable to maintain herself. The children, legitimate, illegitimate, whether married, unmarried, unable to maintain itself. If it is minor, provided they should be minor. If they are major, then they should be physically challenged. If suppose a daughter is physically challenged, but she is married and her husband has capacity to maintain, then no, if she is major. Parents, father or mother, if they are unable to maintain themselves, then they can go to the judicial magistrate first class, within whose territorial and local limit they are resident, that there shall be a territorial nexus. What is the jurisdiction and authority and power of the judicial magistrate first class in this regard? Any judicial magistrate first class may pass an order on proof of neglect or refusal to maintain. You have to apply to the judicial magistrate first class that I am so and so, my relative is so and so, being respondent, non-applicant. He in the law is obliged to maintain and I have no capacity to maintain myself, the maintenance amount is to be decided by the magistrate, and magistrate has a discretion to decide based on the need of the claimant, based upon the means available with the non-applicant or respondent. Accordingly, the court look into the both the side and calculate the thing and pass the appropriate order. During pendency of the matter, to calculate the quantum of maintenance, the magistrate has equitable exercise of jurisdiction in form that the magistrate can grant the interim maintenance during pendency of the proceedings. The court may direct interim payments and a reasonable litigation expenses incurred while bringing the case before the magistrate. Whatever expenses incurred can be till the case is pending, and such applications are to be decided within a span of the 60 days from the initiation of application before the judicial magistrate first class, from serving the notice to the respondent within 60 days. As soon as notice is served to the respondent, from this moment within 60 days, interim maintenance is granted by the magisterial court. Date of effect. Payment, whether interim or final, are to be made either from the date of the order or from the date of application was filed, as specified in the ruling. It is the rationale of the magistrate plays vital role. Now we are going to explain the clause on wife. The term wife encompasses a woman who is divorced and who has not remarried. If there is, suppose sometime there may be no divorce yet caused, even then she is entitled. If there is a judicial separation, even then, sometime no judicial separation, no divorce, even they are separate living. Separate living because of the neglecting approach of the husband, she is entitled to claim. The key characteristic of this scope is the maintenance proceeding is purely secular, gender neutral, applies across religions and recognizes reverse roles. A financially dependent husband may also file, vice versa. That does not mean merely wife can, even husband can. If wife is earner and he has no capacity to earn by any reason, he too can against the wife, vice versa. Because give and take responsibility arises as soon as marriage is solemnized. So inclusive definition of child is concerned, both legitimate, illegitimate children are covered regardless of marital status, with a special provision for disabled children, children minor, major if mentally or physically challenged, if they are not capable. Interim relief enables immediate financial support pending final adjudication, preventing imprisonment. Section 144 provides, if a person having sufficient means and neglect or refuse to maintain the wife, the child, the adult or disabled child, the father or mother, then a judicial magistrate first class may, on proof of neglect, on proof of sufficient means, on proof of insufficient means, sufficient means with whom and insufficient means with whom. If applicant, if he or she has no sufficient means, and non-applicant, if he has sufficient means and neglecting to maintain, then the judicial officer first class is empowered to order a monthly allowances for such a dependent and payment as per the directions. So proviso 1, if a female minor child husband lacks means, if a female minor child's husband lacks means, her father may be ordered to pay until her majority. It means your daughter married, daughter is minor and her husband is lacking to maintain her. So till she become major, you are obliged to maintain her. Proviso 2, the court may order interim maintenance and litigation cost during pendency of the proceedings, and interim application should be disposed within a span of 60 days from the service of notice to other side. Maintenance, interim or final, is payable from the date of order or application. The court decide. The order has effect retrospectively from what moment? On the date of filing of the application, or the date on the date the order is passed. What is practical implication? Protection for dependent family members. It ensures basic needs to meet: food, shelter, education, health care. One shall not be in destitute situation. There shall not be annoyance. There shall not be hunger. Being citizen of this country, the government is not going to maintain you. With whom you marry, let he. Who is your parent? To whom you begotten and born, you are responsible. Prompt relief, interim maintenance, mitigate risk of destitution during legal process. Whenever you enter in legal profession, what kind of cases will come in first hand? The maintenance, wherein we shall not impose the fees. No, we cannot collect the fees. This is free service. Should be judicial flexibility, allows tailoring of maintenance to specific circumstances, including duration and amount. What is legal binding force? Court orders are enforceable with non-compliance subject to further legal implications. If court has ordered to pay monthly that much, one has to pay. If one is refusing or neglecting to pay, or if there is a default, for each default there is punishment. Procedure for maintenance proceeding, section 145. Defining jurisdiction clearly, place of litigation. Mandating evidence recording in the presence of respondent or their advocate. Allowing ex parte order if the respondent avoids service of summon or notice. Despite of service of notice, if he is not appearing before the magistrate, court is not going to wait. Court is not going to serve again and again. Once you realize the matter is against us in the so and so magisterial court, you are supposed to go and submit your say. Despite of notice, if you are not appearing, court proceed and pass the order ex parte, providing a 3-month window to set aside ex parte orders with valid reasons. Once ex parte order is passed, court will wait how long? 3 months to reopen the matter and to hear what I want to say. Whatever your submission, court can heard. How long? Within 3 months. If there is justiciable reason why you are not appeared despite the service of notice, if you shown sufficient reason, then magistrate will heard to you and set aside the ex parte order, and your argument is heard, and then court proceed, and accordingly court take its own turn. Empowering court to award fast and fairness. If approach on the part of the respondent or non-applicant to delay the matter, if it appears, court can impose the cost. Again and again you are adjourning matter, what it is, to whom you are making full. If it appear to the court there is no sufficient cause to delay the matter, court impose the cost. Court don't want the hindrance or delay the matter. Territorial jurisdiction. Who can file? Where can file? Who can file? Why? Second, children. Third, parents. Where to file? Proceedings under section 144, maintenance of wives, of children, of parents may be initiated in any district where any of the following conditions are met. The place of residence, where the present respondent, where presently he is residing, within whose local limit of the district the respondent resides, there, where applicant resides, which district, there, the respondent last resided. When husband and wife, they are changing the place of residence. Then when both of them last time resided, there, where relevant, with the mother of an illegitimate child, the respondent's father or mother, where they reside. So where respondent resides, where applicant resides, where they last time resided, where parent, mother or father reside, there the application for maintenance can be brought in the district. Evidence and collection of recording. In maintenance proceeding, all evidence must be recorded in the presence of the respondent. It means that in absence of respondent, no matter is proceeded. Or if personal attendance is excused on his request, in presence of the so-called his advocate, he appointed on his behalf to argue the matter, then the purpose, the procedure followed, the format prescribed for summon cases, ensuring the formal proceeding. There is no hard and fast procedure, technicalities are followed. This is when formal procedure is followed. How the case, summon case is disposed. Accordingly, the maintenance proceedings are initiated, tried and disposed. There is no lengthy and very complicated procedure. It's very normal procedure is followed. Once the application for maintenance is filed, the court goes thoroughly with the court has to realize who is husband, who is wife, what is means stated, how she is lacking to maintain herself, the territorial jurisdiction, the legality of the marriage is to be ascertained, evidence shown whether they have admitted or denied. If it is admitted, then what? If it is denied, then what? The court has to conduct the inquiry. How much his paying capacity is, how much he is earning. बिलोलीच्या न्यायालयामध्ये असंच प्रकरण होतं. आज 25 वर्षापूर्वीची गोष्ट आहे, 30 वर्षापूर्वीची. When we used to practice at Nanded, and interveningly we used to visit the Biloli court. तर ते बिलोलीच्या बसस्थानकामध्ये एक कपल spouse भिकारी begging they used to beg at the bus stand. सकाळ संध्याकाळ चालायचं, खूप चांगले होते. पण नंतर दोघांमध्ये बिनसलं. One of my colleagues, he initiated matter on her behalf. No fees, pro bono. So even magistrate shocked to know. He knows pretty well what she is, where she is, how she is. The vicinity, the member of this vicinity, they knows pretty spouse. कारण प्रत्येक जण काही ना काही कारणानं बस स्टँडला जाणं, पहिलं आपल्यासारखं प्रायव्हेट ट्रान्सपोर्टेशन नव्हतं, पब्लिक ट्रान्सपोर्टेशन. 168 रुपये कोर्टाने येते द्यायला लावले होते. न्यायालयामध्ये अरे असं कसं मॅटर. मग रिस्पॉन्डंट त्याच्याकडून एक जण मॅटर चाललं, व्हॉट एव्हर इट मे बी. न्यायालय म्हणालं आता 3 वेळेस भीक मागायचं, 1 वेळेस नाही. सकाळी मागायचं, दुपारी मागायचं, संध्याकाळी मागायचं. ते म्हणे ना मी भिकारी, मी काय तू किती मागतो भीक? नाही मी सकाळी मागतो. किती वाजता? सकाळी 6 ते किती? 12. नंतर काय करतो? काय नाही, झोपतो. मग आता काम कर, 2 घंटे झोप कर आणि नंतर भीक मागायला चल. व्हॉट एव्हर यू प्रोक्युअर आउट ऑफ द बेगिंग, फ्रॉम देअर यू हॅव टू पे. बिकॉज यू आर हजबंड. You cannot say I cannot maintain. You have capacity to maintain, then you have to maintain. And for that you have to struggle. आणि म्हणून the court conduct the inquiry and collect the evidence, whatever produced, considered, and accordingly court arrived to the conclusion how much is to be quantum of maintenance should be. Even there can be ex parte proceedings. If the magistrate is satisfied that respondent is willfully avoiding the service or willfully neglecting to appear, they may proceed ex parte without. In absence of respondent, matter is proceeded. The applicant is asked, produce your things, argue your thing. You prove whatever you have contended against the respondent. Though respondent is missing, but whatever you have made allegation, whatever fact you have stated, you prove it. To the extent of proval, the court shows the favor and pass the decree. Any ex parte order passed by the court may be set aside if the respondent applies within the span of 3 months, showing sufficient cause for his non-appearance before the court. And such a relief may be subject to terms, including payment of cost to the opposite side as the magistrate deems it. Cost is for what? The applicant round and round he is appearing, she is appearing, and turning back. For each turn, how much she spent, how much your father and mother spent for the justice, you pay. In addition to monthly allowances. Power to award cost. The court is empowered to order cost in maintenance proceeding under section 144. This ensures fairness, especially if one party deliberately delay or obstruct the process. Suppose a wife in Delhi wants to claim maintenance from her husband who resides in Mumbai. Wife is from? Husband is from? Where matter is to be tried. Under section 145 BNSS, she can file a case either at Delhi or where she resides, otherwise can be in Mumbai where her husband is residing. Is there possibility of any alterations eventually? Does it mean once a application for maintenance is filed and according to maintenance proceedings, once the order is in accordance with the order, particular amount is fixed, does it mean months together, years together, same amount is to be? Eventually, whatever changes taken place in the value, money value, accordingly there shall be alterations. And in keeping in mind such situation, section 146 provides alteration or cancellation of maintenance allowances. Alterations on change of circumstance. What kind of change of circumstance then? If there is a proof that the financial or personal circumstances of a person, either receiving or paying maintenance, have changed, the magistrate has discretion to modify monthly maintenance or interim allowances accordingly. Generally, amount is increased. Very exceptionally, it is decreasing. Loss of job, loss of part of health, incapacity to earn, such a circumstance exists then. Otherwise, salary is enhancing mode. So generally, alteration is positive, not negative. Variation based on civil court's decision. Should a competent civil court issue a decision affecting a maintenance order made under section 144? The magistrate is empowered to cancel or vary the order to bring it into line with that decision. Cancellation in case if there is a divorce or remarriage. You know, कोणता कायदा 2005 चा डोमेस्टिक व्हायलन्स ऍक्ट. You know, domestic violence act. When maintenance is ordered in favor of a divorced woman, the magistrate must cancel the order if the following conditions are met. If such a divorced woman or wife, if she remarries, on proof of her remarriage, whatever order for maintenance was awarded by the court is to be cancelled. If and she has received the entire sum due as per personal or customary law related, इकडले चार लोक बसून ठरवले कुठं महिन्याला घेत बसता, कुठं महाग लागत बसता, एकदाच वन टाइम काय ते सांगा. म्हणजे तू तिकडी, मी इकडी, तू लग्न करायला तयार, त्याला लग्न करायला तयार. So she too can remarry and he too can. So if there is any negotiation, mediation, and according to the customs, according to the tradition, according to the usage, according to the practice of a particular segment of the society, if there is one time settlement, if it is happened, so that can be filed and brought before the court. Both the side parties must appear and court realize and ascertain the fact whether this is compromise entered. Both of you, are you assenting? If both of them, if they say yes, there is no fraud, the court cancel the whatever monthly allowances passed and accordingly one time settlement, accordingly the matter is over. If you paid before the maintenance order, cancellation takes place immediate effect. If paid afterward, cancellation is effective once the maintenance period already covered expires. Post check, कोणता check देतो, है ना? Check bounce झाल्यावर उद्या there are chances. नाही आज चेक द्यायचं ना लगेच कोर्ट ऑर्डर करत नाही, तुमचा हे मी मंथली अलाउन्सेस आहे ते मी कॅन्सल करतो, हे चेक घ्या. नाही, the cancellation of the order may take its effect once the check is drawn. असं she has voluntarily renounced her entitlement to maintenance after the divorce. दैवी शक्ती तिच्या अंगात आली. मला पतीकडून काहीच नको, जेवढं पतीने आजपर्यंत दिलं तेवढं खूप झालं, असं म्हणून जर म्हणत असेल आणि ती स्वतःहून सोडत असेल, then it can be connection to previous law. Connection with the previous law. What is connection? Section 146 of BNSS is mirror the old section 127 of the Criminal Procedure Code, CRPC, preserving its essence, adapting maintenance based on changing circumstances, civil court rulings, divorce events, previously paid sum. In accordance with section 146, it ensures flexibility, fairness, legal consistency in maintenance orders by allowing required adjustment, cancellation, and accurate accounting in line with the related court decisions. Personal changes, the court will look into the capacity. Morning तुम्ही काय घेता, चहा सोबत काय घेता, बिस्किट घेता, बर नंतर असं करता. So day routine during conduct of the inquiry, court ascertain how much the capacity is. नाही मी लय गरीब आहे, बिस्किट खातो म्हणतोय. गरीब बिस्किट खातील का? So on the side of the applicant and on the side of respondent, both try at their level best how much the capacity is and how much incapacity is, and accordingly court ascertain the fact, and accordingly court arrive to the conclusion. It is purely discretion. Court cannot be under the dictate of any ruling. Court has its own discretion. He has to use while exercising the jurisdiction. Court has to exercise jurisdiction powers sparingly, judiciously, fairly. No one shall adversely affect. Section 147, how the order passed by the court is to be enforced. Section 147 plays its vital role. Merely entertaining matter and deciding matter is not enough unless and until there is a coercive mechanism to implement it. Otherwise, it is a mithya. And therefore, section 147 says it provides free copy of the order. The magistrate must provide free of cost a certified copy of the order, the final maintenance order, in terms of section 144, any interim orders including the expenses awarded, the so-called copy. The copy should go the person entitled to receive maintenance, the so-called guardian if applicable, or so-called designated recipient of interim payments. कोणाला द्यायचं, कोणी द्यायचं, कोणाच्या मार्फत कोणी घ्यायचं. So for everyone, the copy is to be given free of cost. Enforcement by and magistrate. The maintenance order can be executed by any magistrate in any district where the respondent, the person ordered to pay, can be found. Matter is, both are resident of Lalu. Matter is initiated, tried and disposed, and thereafter husband left somewhere. He crossed a border. He is now in Nizamabad. The order can be enforced in Nizamabad also. So you cannot leave, you cannot neglect, you cannot refuse the enforcement. Law will follow you. कानून के हाथ लंबे होते हैं. So similarly, this is the replica of the court. The maintenance order can be executed by any magistrate in any district where the respondent person ordered to pay is found. Procedure for enforcement. How order is executed. How one is compelled to pay. The enforcing magistrate must be satisfied two conditions. One, has to identify the parties involved, the claimant and respondent. Second, the maintenance or expenses remain unpaid. Two things must be considered. before whom the order for enforcement is applied. काय काय पाहिजे? दोन गोष्टी. एक, कोण कोण त्या प्रकरणात होतं, कोण हजबंड कोण वाईफ, हु इज अप्लिकंट हु इज रिस्पॉन्डंट. आणि दुसरी बाब, कधीपासून अनपेड आहे, कधीपासून, आणि या दोन बाबी इन्शुअर करणं गरजेचं आहे. Once the magistrate is satisfied two of the things and things are ascertained, the magistrate can proceed to enforce the order through recovery of amount due using the power granted by the BNSS. आणि ते enforcement order करण्यासाठी the magistrate is empowered to adopt the means. हे चाललं गेले हो. Link to farmer law. हे चाललं. This section essentially mirror 128 of the old CRPC. हे चाललं. This provision is flexible for execution across the jurisdiction. कार्यक्षेत्राच्या बाहेर सुद्धा जाऊन हे execution process या ठिकाणी होते. Old mechanism is equally followed here. चालतं? Provisions for imprisonment. If the person failed to comply with the maintenance order without sufficient cause, the applicant has initiated complaint application, summon served, you appeared before the court, both of you heard time and again. How much struggle on the part of the applicant in bringing before the court? You compelled. You are merely compelled her to appear before the court, and now, after all, with all struggle, the amount, final amount is decided, and now you are refusing. What to do? To whom you are making full? So, keeping in mind the severity of the circumstance, the magistrate is empowered to issue a warrant for recovery of the amount due, whatever it may be, 2 months, 4 months, 6 months. And even is empowered to sentence the defaulter to imprisonment for a term up to 1 month, or even until the payment is made for each month's default. This is similar to the old CRPC provision under section 125 clause 3, and ensure compliance through coercive measures. But imprisonment is not automatic. It is last resort after recovery attempt fail. That does not mean once he is paying and at one of the month he is defaulter, there won't be automatic process to punish. No. That is different matter. That is different matter. You are paying for month January, February, and during the month of March, because of the last month of the financial year, some everywhere the problem is, and you are the defaulter. Law cannot automatically work to punish for the default. No, you are not going to send to jail. Your intent is plays vital role. So imprisonment is not automatic. It is a last resort. By adopting other measures, if still you are not paying, then the last resort is to send him jail, and until he pay, arrange, you remain in jail for month.
Then how will he be able to pay, being in the
His next wife has to arrange. His relative has to arrange. He will do. Once he realize things will go at high, he will rush here and there. he knows pretty well the consequence. This is just what I mean to say, release the anger of the system, of the law against the person. Despite of that much struggle, you met the magistrate to engage for time and again to heard your matter, and now magistrate has calculated the things. Huh? What you said, only that much is capacity, and court relied upon your argument and decided, and now you are not paying. What senseless practice you are practicing then? And if you are defaulter again and again, the court will take its own course. That does not mean it is a contemptuous act. But she is away from the so-called bread and butter. How she can be kept destitute in a destitute condition? This is social justice legislation. This is not a legislation to take the revenge. No. हा रिव्हेंज घेण्याचा उद्देश नाही आहे. हा उद्देश काय, कोणी भूक मरू नये या भारतामध्ये, हा उद्देश आहे. याचा अर्थ असा नाही की सरकारनं द्यावं, नाही. तुम्ही जिम्मेदारी घेसाल आणि सरकारला जेव घाला म्हणसाल, असं कसं होईल? मग तो कोणीच काम करणार नाही. 2-2 लग्न करतील, तुम्ही जेव घाला, मी लग्न करतो. हां, असं आईच्या जीवावर बाईजी काय उदार म्हणतात, तसं होईल हे. तुला लग्न करायचं तर तू जिम्मेदारी घे. म्हणून बरेच लोक लग्नच करत नाहीत, नकोच ते किटकिट. ते बरोबर आहे, नथिंग इज रॉंग. है ना. इफ यू आर एंटरिंग इन द वर्ल्ड ऑफ मॅरेज, देन यू आर इन रिस्क. आता सावध सावधान समयो, आता सावध होण्याची वेळ आलेली आहे. यू आर बिगॉटन अँड बॉर्न अ बेबी, यू आर रिस्पॉन्सिबल इन द आईज ऑफ नेचर. अरे प्राणी सांभाळतात आपल्या लेकराला, सोडून जात नाही. हत्ती 12 वर्ष त्या कळपामध्ये राहतो, 12 वर्षानंतर बाहेर काढतं त्याला, त्याचे आई वडील बाहेर काढतात, पण 12 वर्षात त्याला सोडत नाहीत. दिस इज द नेचर. सो यू आर ह्युमन बिईंग. What kind of human you are if you are neglecting, despite she is compelled to appear before the court, and after a struggle the quantum of the amount is fixed, and now you are not paying. What a shameless thing. It is ridiculous. Therefore the provision is made, there shall be a coercion, and out of such coercion he is compelled to pay. उद्या नांदगावला जावं लागते बघ म्हणलं की बस. हो ना, एक दिवस जरी नांदगावला जाऊन आलं तर बस झालं ना. असं हा, वेळच लागत नाही. हो, त्याचा काय उपयोग आहे किंवा मला the ultimate goal is not to take revenge. Ultimate goal is compliance. कंटेंटमेंट काय म्हणायचं त्याला? तिला पैसे मिळाले ना 500-500च्या त्या नोटा, बस आता बघू पुढल्या महिन्यात. अदरवाइज she will be in agony, pain, sufferings, है ना. सांगतो, आपली गाडीपेटीमुळं स्वयंपाक होत नाही. हो, गाडीपेटी नाही म्हणून जर तुम्ही स्वतः कुक करत असाल, संध्याकाळची वेळ झाली आणि आपल्याकडे आता शेजारी विकून गेले, सगळे झोपी गेले, पैसे आहेत, काय तांदूळ खाणार आहात? पैसे असून हिच्यात करता पैसे बी नाही. किती अवघड अवस्था आहे. सो पर्पज इज नॉट टू टेक रिवेंज, पर्पज इज नॉट टू टेक टू पनिश, पर्पज इज टू entitlement, contentment. So section 144, file a maintenance application, spouse, children, parent. 145, proceed under procedural law, jurisdiction, service, ex parte if needed, cost, control. 146, adopt modification of order, overtime, per changing circumstances, as per changing higher court decision, providing flexibility, fairness. 147, ensures compliance, pre-document provision, identity verification, enforcement across jurisdiction without payment, beneficiaries receive order copies free of cost, enforcement enforcement is permitted by any magistrate where respondent is present. Clear verification of identity and non-payment is required before execution. This ensures effective, streamlining enforcement maintenance obligation under maintenance. In this way, section 144 to 147 is over. If anything else, it will be else. छोटे छोटे प्रश्न असू शकतात.
How illegitimate children are eligible for maintenance? कोणाच्या साईडचे तिच्या का त्याच्या?
Eligible नाही, legitimate, illegitimate.
तेच
Legitimate, illegitimate. तुम्हाला legitimate child म्हणजे काय तुमच्या नजरेत?
त्या दोघांपासून द्या.
अच्छा. Illegitimate कोणाला म्हणतात?
अनैतिक असं
अनैतिक म्हणजे काय? समजा लग्नच झालं नाही आणि अशीच झाले लेकर. इलिगल चाइल्ड. जगाच्या नजरेत आहेत पण त्याच्या नजरेत लेजिटिमेट. आता तुम्ही लग्न करताय त्या महिलेसोबत एक लेकरू आहे. हा, तुम्ही त्या लेकरासोबत लग्न करत आहात. लेकराच्या आईसोबत लग्न करत नाही तुम्ही, ते कुणासोबत लग्न करत आहात? जिम्मेदारी फक्त त्याच्या आईपुरती घेत नाही तर तुम्ही जिम्मेदारी शेळीसोबत पिल्लू बी असं. ते गोष्टी आल्या पुढे, वेगळ्या झाला तो विषय वेगळा झाला.